Hello and welcome to the second part of our August cost vlog. If you haven't yet had the opportunity, please don't forget to watch part one. In this section, I'm once again joined by Adam Burrell, Charles Crow and Richard McLoughlin, where we discuss solicitor client assessments, in particular success fee challenges following Herbert and HH law. We also delve into the new cost budgeting changes, the new Precedent T concerning variation of cost budgets, which of course comes into force on the 1st of October. I do hope you enjoy. Thank you.
Touching upon awkward decisions, awkward conversations between solicitors and their clients. And I think that turns on a new cottage industry. We've all seen PPI reclaim. Well, now we're seeing success fee reclaim. We're not necessarily seeing it on our TV sets quite as predominantly as we do PPI claims. But of course, following Herbert, solicitor client assessments it's a brave new world, isn't it, Richard?
It is, yeah, and it's particularly uncomfortable, unfortunately, for a lot of claimant solicitors. In my own experience, I've had a number of approaches in relation to the issue, and I know that other members of the chambers have as well. Essentially, Mrs. Herbert brought a claim in respect of a very straightforward personal injury. She sustained, she was a passenger in a vehicle that had a rear end shunt by a bus. Liability was admitted, her injuries were very straightforward, soft tissue injuries, causation wasn't an issue. The matter settled, the claimant solicitors then submitted a bill to her in respect of a success fee. She instructed solicitors to challenge that, saying that the success fee was too high. The matter proceeded all the way to the Court of Appeal. And what the firm of solicitors had done in that case was simply impose a uniform success fee on all of its low value personal injury type clients of 100%. And that was regardless of any of the risks in the case. They explained that essentially it was part of our business model, and other firms were doing it as well. And the Court of Appeal said, no, yeah, it's not informed consent. You can't call something a success fee if it has no bearing in relation to the risks in the case. And so, unfortunately, it seems that quite a few firms are receiving these types of letters and having to address the issue. In that particular case, the claimant made quite a small saving. I think that because, of course, the success fee would be restricted to 25% of general damages and past specials in any event. The risk was assessed at 15% rather than 100. But her solicitors recovered costs of the assessment of £4,500. So one has to be aware of it.
And it's a skeleton in the cupboard because, generally speaking, a lot of firms haven't just thought that it's a blanket 25% of damages that they can get back. That's the quid pro quo of the reforms, and haven't really thought about the need for risk assessment. And if a risk assessment exists, it will just say 100% for very benign factors.
Yes, and I think that. Sorry,
Richard, go on.
Well, I just think a lot of firms felt that that was something which would be acceptable, and maybe it is the case. I think the Court of Appeal actually left it open to say, if you tell your client at the beginning that this 25%, we're calling it a success fee, but it's not, it's just we're going to charge it. If you tell the client at the beginning, then maybe it will be recoverable. But it's arguably misleading to call it a success fee in itself if it really isn't one.
It's a bit like a return to the good old days of the endless challenges to the enforceability of CFAs and what fun that we had doing that. I have to say I enjoyed it, but it's back to that. But I don't have a huge amount of sympathy for solicitors who failed to read the rules properly, to realise that it remained the case that you had to link your success fee to the actual risk in the case. And misread the rules as suggesting that there was some sort of fixed percentage that you could recover, as you say, Chris. I mean, it's just misreading of the rules. And if ultimately it comes back to roost and they pay for that mistake, well, it's difficult to have a huge amount of sympathy. In the same way that in the 2000s, if people didn't read the regulations and do what they needed to do and dot all the I's, cross all the T's to ensure their agreements were enforceable, although it's obviously a bit of a shame for them to have done all the work and not got the benefit, and the payment they would otherwise deserve, if they've not followed the rules. I suppose it's a very legalistic approach, but it's difficult to have huge amounts of sympathy.
Yeah, I quite agree. And I think for all the firms out there that are just pillaging the last little bit they can out of PPI reclaims. Well, they only have to change 3 letters. Instead of PPI reclaim, it's CFA reclaim, and maybe we should get involved with that. We should. In fact, CFA reclaim. I'm .com. I'm registering that at the end of this conference.
Oh, well, I'm told that that's one of the reasons there's such backlogs in the SCCO for getting your cases listed, because of all the applications for Solicitor Client Act assessments, because of all the reclaims. So it's their fault.
Yeah, it's interesting, isn't it? Because it used to be relatively unheard of that clients would exercise their rights under the Solicitors Act, but it's whether they are happy.
Absolutely, and I think because of this, because of the cottage industry, so that there's more than ever taking place and applications taking place, the whole system of Solicitor Client Act assessments is now under some degree of scrutiny. I think last year, one of the conferences that I went to, the senior cost judge said that as far as he's concerned, it's now a priority to actually overhaul completely the way that Solicitor Client Act assessments, because it's very archaic. It's, you know,
it is, isn't it?
It's very clunky. There's this lack of clarity, and it's not needed to be sorted out, because there haven't been, relatively speaking, there haven't been that many assessments, so we haven't really needed to worry about it. But it's like all these things, when you start to have a pressure point on public resources, then all of a sudden they think it's a good idea to make it a bit better. But I think during that, so it was last year, I think he said even then, before we were inflicted by the plague, you know, it's just not high up the agenda at the moment, because there's plenty of other things to sort out. So goodness only knows where that is now. I've not heard anything anywhere that there's any impetus to look at that and address it, but we'll wait and see.
Yeah, absolutely. Yeah.
Precedent T, is it Mr. T or Precedent T?
No one knows, because he remains anonymous.
Yes, we are eagerly awaiting a flavour for how the courts are going to approach the new practice directions and the new Precedent T for variation of cost budgets, following a bit of a disjointed approach thus far on whether parties bother updating their budgets at all and how they do that, or whether it comes to a detailed assessment and try and argue that that's a good reason to depart from the budget. But now we actually have a change in the rules to see for the courts to tackle these issues prior to the conclusion of the case and before the horse is bolted. Charles, what's your view on the new rules? Do you think that it's going to be helpful?
Yeah, well, I think it obviously does. The changes is an amendment to the CPR, to the rules themselves. It also meant a complete revision or replacement of the practice direction. It obviously goes wider than just the process of varying budgets. And I think, in a way, we've been in a somewhat messy state of affairs since October last year, where we had quite an extensive guidance to the Form H. We had the practice direction, we had the rules, we had 3 sources, as it were, of requirement, and this will at least reduce it down to 2. A lot of things that were in the practice direction have been moved into the rules, and what were just in the guidance have been moved into the practice direction. So, for example, the standard assumptions are now in the practice direction. So I think it's going to tidy things up. It's going to tighten things up, because some things are now in the rules that previously weren't. So the power to budget in non-budget cases, the power to limit budgets to certain, just do the budgeting exercise for certain phases or parts of a case, the rules in relation to who can sign budgets, those sort of things, are going to help. There's a new paragraph in the practice direction about oppressive behaviour. I think unreasonable applications being made, and I think a welcome addition in relation to interim applications, that they can be treated as out with the budget. That's now in the rules. So I think all of those things are helpful in tidying things up and strengthening things. But as you say, the major change probably is the Precedent T and the hopefully clarification of the process for variation, because I think previously there was a certain amount of confusion as to how you went about it, making clear what was in the previous budget, what you're adding, and so on and so forth. But in one sense, we're talking about it slightly too early, because unless and until we see Annex whatever it is of the practice direction, which contains the new Precedent T, it's a bit difficult to discuss how effective we think it will be. And as far as I'm aware, they still haven't released it, have they? We still don't know what it's going to look like.
I've seen a draft. I don't know whether it is.
I think it's in unofficial circulation.
Yeah.
And the dark little sort of
The dark cost
that,
lib. Yeah.
that people like Chris and I frequent. But it's actually fairly. It's all over the place in terms of like LinkedIn and those sorts of places.
Right. Well, I haven't seen it, so I can't really comment on whether it looks like it's going to significantly make it easier or not.
It looks like a fairly pragmatic document in the same way I think a Precedent H is a reasonably useful document, and it gives where we're at, where the variation is up or down, and yeah, it's got a few extra colours, so it looks a bit more pretty. There's a bit of green on there, but
it looks attractive in the sense that it's fairly simplistic, and it does look user friendly. The two issues that I've got with the amended. So the amendments to how you go to amend a budget are twofold. The first one is there's no obligation to reveal what's on the clock. Now, what I mean by that is that, and the new precedent and the rules basically uphold the so-called sharp v blank workaround. So we've had this huge problem ever since budgets were introduced. What do you do when you vary a budget? With the fact that by the time you come to present your variation, there are lots of costs on the clock, which by that point have obviously become incurred. So when you have a budget that's approved, say 12 months previously, you then send in your amended budget. And in that 12-month period since the last budget was approved, you've obviously got 12 months more work on the clock. They then become incurred. The problem with the fact that they've then become incurred as a matter of fact is that incurred costs, as we know, are not in the scope of the Court for Cost Management. They're subject to an unfettered detailed assessment. The sharp v blank workaround is that you basically cheat and you pretend that all the costs which have been incurred since the last approved budget, you treat them as estimated future costs. So although they're incurred, you pretend they're future, and then you just add on the extra bit that you need. Generally speaking, everybody kind of accepted that's probably the best way you can budget, because there's no real way to do it. And Precedent T confirms that's exactly what you do. So if there's been a significant development, you say, I need a bit more from what you gave me last time, and you pretend that the costs which you've already incurred are still future costs, and then you put that in your amended budget. Now, before Precedent T came in, and currently, I would certainly generally always agree to adopt the sharp v blank workaround on one condition, and the condition is that you tell me, so if I'm acting for one party and I'm served with an amended budget, they want to follow the sharp versus blank workaround, I will say, well, that's fine, I'll go along with that. We'll pretend that the costs you've now got on the clock are to be incurred, even though they've actually been incurred. But I need you to tell me what you've spent. I need you to tell me what you've spent since the last budget, so I can consider whether or not your amended budget is reasonable. And just to use a very practical, basic example, let's say that for a phase you were given 50,000 to spend, and you now say something's happened that you didn't anticipate and you want some more money to spend. So you say to me, well, that was 12 months ago, I was given 50,000 to spend, but something has now happened, which means I need to have some more. So I now want £75,000, an increase of £25,000. Well, how do I know whether that's reasonable without knowing what you've spent in the last 12 months? It might be, for example, that you've actually been able to underspend on your assumptions, so that your request for £25,000 is, on the whole, not reasonable. Or equally, it might mean the real reason you're asking me for an amended budget is because you've overspent on your allowed budget previously, and that this is actually a bit of a ruse just to try and cover over what you've already spent. Now, the point I'm making, in fact, in practice, might not matter, because I find that generally, when submitting an amended budget, currently adopting the sharp versus blank workaround, parties will tell you what they've incurred on the clock, because it will be, if they've got a strong case, it doesn't matter, of course, and they'll show you. But we do have some resistance. there's nothing in the amended rules that we can see. There's nothing in the practice direction which makes it an obligation to tell you what you've actually got on the clock.
Is the argument, though, that it shouldn't really matter what has or has not been incurred? At the end of the day, if the court is satisfied that the development that has incurred is sufficient to warrant some more money, and that wasn't something that could have been at the previous CC.
Absolutely, yeah. That's the counter argument. I would say that's the lazy option, though. Because that's but that's going to be extremely attractive to a court service which is hard strapped. Resources are tight, and it's clear that the system and the proposed precedent steers away from going into the nitty gritty. But I would say, and I always do say, and I have said, and I will remain saying, you can't just press a button and tell me what you've got on the clock. Of course you can. You can tell me. It's because otherwise you wouldn't be here if you can't tell me, because you're only here possibly because you've overspent. But that's certainly going to be an issue, I think, which is going to have to be played out, and we're going to have to see whether or not. The other point, which is probably more important actually, is, well, great, okay, but does it matter? And the reason why you've got to ask, does it matter, is we still haven't got an answer as to whether or not failure to get a departure from a budget mid proceedings in any way impacts or debars you or is fatal to an application in the detailed assessment for good reason. There is, I think, a change to the rule which makes it clear that going for an amendment is mandatory, and certainly in the authorities it's always been made clear that you should apply for an amendment prospectively. You shouldn't do it retrospectively. So you ask for the amendment before you actually spend the costs. Anybody in the profession knows that that's just entirely impossible, because by the time you get any sort of an application listed to go and spend some money, it's too late. You've already spent the money, so it's just not possible. So what happens then if a party makes a conscious decision not to bother to apply for an amendment, carries on, overspends, gets the detailed assessment, and just says, well, I decided not to go for I decided not to go for significant development, I decided not to vary, I'll just go for good reason, and I'll just say I want good reason, my good reason is X, Y, and Z. And we've still got absolutely no clarity over whether or not that's a perfectly reasonable and plausible approach.
And that argument is going to do the rounds, because, as we all know, there's litigants out there, solicitors out there, that won't know of the new rules and think, I'll just argue good reason.
Good reason at the end, yeah, absolutely.
There is a flavour that the good reason, that because of the different terminology, good reason to depart at the end should be a higher bar than a prospective application within the proceedings to vary. But that's an interesting point that you said. I was talking about this today, in fact, and I was persuaded that it's probably the other way around, that significant development is probably a higher bar than good reason. But I mean, but that's the whole point. Do we?
No clarity, yeah.
Straight away, we're diametrically opposed there. So it'll be interesting to see.
I think that probably the answer is that if you fail to make a prospective application to vary, that you will find it harder to persuade the court that you've got a good reason at the end, especially if the court thought that you should have made the prospective application. So I suspect that you will probably never get any guidance, because it will be left to the good sense of the judge on a case-by-case basis. I was just going to also say, in relation to the first point about being told what the time is on the clock, there may be a policy reason why the drafters won't legislate for that, and it's this, that the basis of the argument that I should know what's on the clock is that essentially, if you've managed to underspend thus far, contrary to what was expected at the first CCMC, then I should be able to take that into account at this stage when deciding whether or not there should be a variation. But the effect of that is essentially to appeal the decision with the benefit of hindsight. You're appealing the decision of the judge at the CCMC with the benefit of hindsight of what actually happened. And there may be, I'm not saying I agree with it, but there may be an argument that that's why you should separate out the issues, so that at the variation hearing, all you are considering is Is this an unexpected step that wasn't taken account of at the first stage? And if so, what's the appropriate pounds and pence, regardless of whether you've done well or badly since the last CCMC, because that should be irrelevant, because otherwise it's an appeal by the back door.
I agree. It'll be interesting to see how that one unwinds. I suspect we might have a slow take up to begin with, but give it 12 months, will be these sorts of arguments might be routine. But also, I very much think that the point you make there at the end there, Charlie, is that somebody is very unhappy with an outcome in a CCMC might look at this as a second bite at the cherry, if almost looking for something to change, just waiting for that one thing and think, yeah, all right, let's go and have another go. Different judge, different day, who knows?
Yeah. Absolutely. And then I can't remember which case it was, but there's some authority to making the point that you shouldn't have to put the kitchen sink in the assumptions, because it's just going to be the whole process will just grind to a halt. So if you have very prescriptive and lengthy assumptions, and then as soon as something happens that you haven't put in the assumptions, you put in your precedent T and good reason. And let's face it, the more applications to vary budgets that are made, the slower the whole system, the slower the proceedings, the slower the system, and it just brings everything down. It would be interesting to know what approach a judge might make of a reason for not applying for an amendment during the proceedings, simply being that you didn't want to trouble the courts and you just leave it for detailed assessment.
Absolutely.
I've certainly seen that argument put within detailed assessment before. I think that the test case issue on this would simply be where, at a detailed assessment, a cost judge refused good reason purely because the party failed or didn't make an application to vary during the proceedings. But what often happens is, because of, as we know, judges are extremely smart, what they'll say is, well, I note that you didn't apply during the proceedings, but it makes no difference because I wouldn't have given you good reason anyway.
Yeah. Well, it'll be interesting to see. Well, I think perhaps we can reconvene in 6 months' time or so. Hopefully, we'll have seen what we'll reconvene. We'll see what the Court of Appeal has to say. We'll settle that £5 bet, and we'll see how these things are starting to work.
Probably be 12 months at least before the Supreme Court gets round to that, and you can give me the fiver then.
Well, Adam, thank you so much for joining us. It's been a real pleasure to have you involved, and thanks to Richard and Charlie. Great.
Thank you for having me.
Backgrounds there. I like your wallpaper, Adam. Richard's a very clean-minded man, I can see, and save for you, Charlie. But pleasure speaking to you all, and we hope to have another one of these again soon. So thanks for everybody who will have watched this, and hopefully you've picked up something useful.